Good morning. The different concept of consensual sex charges under Section 376. The Supreme Court has verdicted in a different way, wherein a 35 years old advocate, having married and subsequently due to some dispute separated from her husband and developed intimacy with other advocate, co-advocate, while participating in some functions, and continuously they were having sex, and since he did not marry her, and she filed a complaint stating that by promising marriage he married her, but actually the FIR final report was filed under Section 376 Class 2, continuous raping of the woman. That was wrongly misconceived by the... Okay, whatever it may be. The ratio is most important to understand. This is the AR 2026, Supreme Court 810. AR 2026, Supreme Court 810. The Bharatiya Nagarik Suraksha Sangita 528. Causing of proceedings. Prima facie case. Offence of rape. Allegation that accused appellant raped victim on false promise of marriage. Victim 33-year-old advocate and mother of a 10-year-old child. Entered into relationship with accused while her marriage was still subsisting and divorce proceedings were pending. For a promise, this is most important, for a promise of marriage to vitiate consent, it must be shown that accused had a lucid interval of deception. Lucid interval of deception. From very beginning, solely to obtain sexual factors. However, both parties were fully aware of existing marital status of victim, which rendered any such promise legally unenforceable under marriage laws. Victim was legally trained professional and not a naive individual. Then again, important concept. A promise to marry a person who is not legally eligible to wed cannot be estimated a misconception of fact that would override free consent. So, misconception of fact that will override free consent. Allegations, even if taken at face value, depicted a classical consensual relationship and acrimonious rather than a criminal act of rape. Allowing prosecution to continue would be an abuse of process of law. FIR charge sheet consequent proceedings were quashed. And this Supreme Court judgment had dealt with several earlier judgment about this consensual sex. This is the state. Naeem Ahmed was the state of New Delhi, NCT of New Delhi, National Capital Territory of Delhi. That allegedly prosecutor has also given her consent for a sexual relationship with the accused appellant therein upon assurance to marry. The prosecutor, who was herself a married woman having 3 children, had continued to have such relation with the accused appellant at least for about 5 years till she gave complaint. In the conspicuous of such facts as the court had observed as well. So this is also one of the important judgments. Then they have also discussed yet another judgment. This is Mahesh Damu Kare as a state of Maharashtra. Promise to be a false promise to amount misconception of fact within the meaning of section 90. It must have been made from very beginning with an intention to deceive the woman, to persuade her to have physical relationship. Therefore, if it is established that such consent was given under misconception of fact, The said consent is vitiated and not a valid consent. So that most important judgment. Another judgment, Bhajanlal, that is Bhajanlal case is about quashing the proceedings. Okay, take care. Best wishes.